Welcome back to America Decides. We are following breaking news this evening. Judge Tanya Chutkan has made public portions of a key filing in the Trump 2020 election interference case. I want to bring in Harry Litman. He served as Deputy Assistant Attorney General and now hosts the Talking Feds podcast. Harry, your big takeaways from this filing?
Well, my number one takeaway is that it was actually uncovered. Trump has tried very hard to keep all this information from seeing the light of day. Now it is out. The cat's out of the bag. He can't try to appeal or keep it from being there. So it has an immediate impact as sort of an October surprise in the election. In the substance, we have all kinds of new evidence, bombshells, really a fusillade of shock and awe from Smith, starting with Trump statements. He wasn't in front of the grand jury, but people were who heard him. They've given many of his statements. They're all going to be admissible at trial. They show he knew just what was going on. Second, Mike Pence statements. Remember, he wasn't there on January 6th, but he testified to the grand jury, and he lays out really a chilling campaign by Trump to make him try to break the law. And finally, on the Pence point, two more things, actually, Major. We know that when Trump, and it's the evidence is there on page 75, when Trump was saying to the crowd, Mike Pence has to do the right thing, he already knew Pence had decided against it, meaning he knew the crowd would be completely riled up when they found out that Pence wasn't going to do it. Finally, the issue on law. Does Pence evidence come in? The argument here by the special counsel on page 90 of the brief is it should come in because Pence is basically acting in this exchange as the head of the Senate rather than as Trump's sort of second in command. And that's the argument why it fits in the Supreme Court's rubric.
Harry, I want to pull on one of the threads from what you just told us, because the Trump campaign, feeling a bit pressurized by this unsealing, says its timing is suspect. It's happening right after the vice presidential debate. It's happening in the teeth of the campaign. Therefore, it's election interference because it's creating all of this attention on something possibly injurious to the political fortunes of the former president. The timing of this is a reflection of both sides working on their briefings and the timing. And much of this has been pushed into this campaign, if I heard you correctly, by efforts from former President Trump's legal team.
That's exactly right. And Judge Chutkan, who made the decision to open it to the public, has been more than any judge in these last couple years impervious, wearing blinders about the election. She says, that's not my lookout. Just yesterday, Trump came in with a very strident brief saying, don't do it. It will affect my election prospects. It'll be election interference. But that's not what the immunity decision was about from the court, right? That was about whether a jury could hear things. So Chutkan made the decision that that doesn't change the ability of the people, which is presumed under the law, to see this brief. And people are combing through it now, Major, and there's just bombshell after bombshell identifying who is P5 and who's P3. But the bottom line is there's going to be many days where people are reminded, and this dovetails with what you said about the vice presidential campaign, where J.D. Vance just couldn't say Trump had lost because Trump refuses to say it. It's going to really chafe against those claims of his, and I think have an impact on the election.
Harry, you know this, I know this, but some in our audience may not. Testimony before a grand jury is not subject to any cross-examination. There's no defense attorney there. This is the prosecution building its case with as many witnesses as possible. Understanding that, how do you think Trump lawyers might try to argue against some of the revelations you've just described as bombshells?
Well, they can argue in court, of course, when this comes to trial, if it comes to trial, as it won't if Trump wins the election, and then they can cross-examine. There's a lot they can say. It just so happens that the process that the Supreme Court put in place was tell us everything, DOJ, so then the judge can figure out where is immunity and where isn't. And for that, The biggest point is just that it now has been revealed. You're absolutely right that when it comes up in trial, there'll be things they can try to do. But the mere fact of it, Major, we didn't have these statements before. And everything that a witness said in the grand jury that Trump said, that is going to be admissible at trial under the rules of evidence. So many of his own words are going to be used to try to convict him if this comes to trial.
Words he spoke, relayed to the special counsel by those closest to former President Trump, people he hired and trusted. We should remind ourselves of that throughout. Harry Litman, as always, thank you very much.
Thank you, Major.